Justice, Korean Court of Justice, Original Jurisdiction, Case Management Conference in TTOJ number 1 of 2024 between Derek Ramsamooj and the State of Suriname. The proceedings may be viewed in Dutch on the court's Facebook page. The English and sign language interpretation are also available on the court's YouTube channel. The members of this morning's panel are Mr. Justice Anderson, presiding judge.
Good morning, counsel and agents.
Madam Justice Raj North Lee.
Good morning, everyone.
And Madam Justice Ononewu.
Good morning, everyone.
May we have the appearances, please? Thank you.
Your Honours, may it please you, my name is Justin Phelps. I appear for the claimant, Mr. Navindra Ramnanan and Mr. Milton Caslen of the Surinamese Bar also appear with me. We are instructed by Mr. Chase Pigas.
Thank you. For the defendant. Madam Deputy Registrar, is there the agent for the defendant present?
Mr. Liverpool, he was with us earlier on. Wow. Judge, I am not seeing him. Could you just give us a moment? Thank
Sure,
you.
sure.
Judge and members of the bench and council, our team, we are trying to relocate to find Mr. Liverpool. He would have been in originally, and we're not sure what happened when we came out. So, Judge, you may have to bear with us and maybe stand the matter down, and our team will try to contact him. Is that all right, Judge?
That is fine. So we will stand the matter down for a few minutes.
Thank you so much, Judge. Thank you, and thank you, counsel, again, and the staff of the CCJ for your patience. Thanks so much. Do not leave the space, please. You can take your cameras off, but please stay in the space. Thank you.
Okay.
Mr. Liverpool, are you in? Are you hearing us from the CCJ?
Yes, I'm hearing you, ma'am.
Okay, just a second. Justice Anderson, presiding judge and judges and staff and counsel, Mr. Limapu is in. So, Mr. Limapu, you are at the stage where you would have to give your appearance. So, judges, can we see you on camera? Great. Mr. Limapu? Mr. Limapu, are you hearing us from the CCJ?
Yes, can you just give me like 5 seconds, please? 5 seconds.
Certainly, the bench will do that. Justice Anderson, it's over to you when he's done, please, Judge. Thank you.
Thank you.
And Judge, Justice Anderson, please also remember Ms. Peak is here, so she will also have to make an appearance, please, Judge. Thank you.
Thank you.
Thank you. Yes, Mr. Limapu, are you here with us still? Mr. Limapu, are you hearing us from the CCJ? Mr. Limapu?
Yes. Yes.
Yes.
I do apologize for this.
Yes. Are you ready to give your appearance now, please?
Yes.
Thank you.
Yes, I will. Good
Yes.
morning, Your Honor. My name is Hans Limapo, and I represent the state of Suriname.
Thank you, Mr. Limapool. And I gather we have an agent for the state of Trinidad and Tobago who is holding a watching brief.
Yes, good morning, Your Honors. My name is Deborah Peak. I appear for the state of Trinidad and Tobago, the member state of the claimant. I am instructed by Ms. Laura Passad and Laura Lee Hackshaw of the Civil Law Department. And as Your Honor indicated, we hold a watching brief in this matter. We do not propose to participate, and we have made no application to intervene. Thank you very much.
Thank you, ma'am. Well, council agents, thank you for bearing with us whilst we had that short technical glitch. I hope we're now free of those glitches going forward this morning. As you are aware, the court granted special leave in this matter on the 10th of October last year, and we are now in the process of ensuring that the matter is prepared for trial, and we therefore have to attend to those procedural matters necessary for that event to occur. There are a number of procedural issues that the court has identified, and we will go through them as we see them. We are obviously open to any comments or suggestions that you may have in relation to those matters that we raise, and also in relation to any new matters that you may wish to raise. I would want to just give the opportunity right at this moment to ask either side if that way of proceeding is acceptable to you, or do you have anything of a very urgent matter that you need to bring to the attention of the court?
Not for the claimant, Your Honor.
Thank you.
Not for the defendant either, Your Honor.
Wonderful. Thank you very much. So the first item that we considered useful to give some thought to is the question of the pleadings. We know that the originating application has been submitted, and we know that the defense has also been submitted. The question here is whether the parties feel that they wish to have further pleadings submitted in this matter. As you're aware, the rules allow for there to be a reply from the claimants and a rejoinder from the defendant, I should say the claimant, and a rejoinder from the defendant. This, of course, is at the discretion of the court, but normally the court would accede to the wishes of the parties. So the first question for the parties then is, do you wish for there to be the submission of further pleadings in this matter? Mr. Phelps?
Your Honors, the claimant does not propose to file a reply to the defense that was filed.
Okay. Well, that is very clear. If there is no reply, Mr. Liverpool, I don't suppose there's any room for a rejoinder. Would you agree?
Yes, Your Honor, I agree.
Wonderful. Thank you very much. So we have disposed of the first issue. No further pleadings in this matter. Pleadings are closed. Second question has to do with the possible appointment of an amicus. As we are aware, the court has the option of appointing a friend of the court, an amicus, who could assist the court in the matter before it. The court also has the power to allow the parties themselves to indicate persons, entities who could be amicus in this matter. I should say that having consulted with my sisters on this panel, we are of the view that given the nature of the proceedings, in particular, given the emphasis being placed on the Charter of Civil Rights, or the Civil Rights Charter, I think it is called, and also on the broader question of the rights enjoyed by CARICOM nationals in the territory of other member states, that we thought that the submissions from CARICOM could be useful to the court. And therefore, we propose to invite CARICOM to be an amicus in this matter. I would obviously make the point that, as you are aware, both sides, the amicus simply provides an opinion to the court. We would expect that the amicus would provide arguments for both sides of the question, but of course would not provide or purport to provide a final answer on any of the issues before the court. That's not the function of the amicus, simply to assist the court in considering the matter. So two questions. One is there any objection from either side to the court's appointment of the CARICOM, and in particular the General Counsel of CARICOM, as an amicus in this matter? And two, whether counsel agents have any other suggestions about who may be amicus. Mr. Phipps?
Honors, we have no objection to CARICOM being appointed as an amicus to the court, and we have respectfully, no suggestion to make as to your second question.
Thank you, sir. Mr. Hans Liverpool?
Your Honor, we have no objections either to the appointment of the CARICOM as an amicus, and we have no other suggestions either.
Thank you, sir. So that is wonderful. So we will then propose to invite CARICOM to be amicus in this matter. And we will share, of course, with you the communication issuing from the court to CARICOM. The next item we propose to discuss is the item of witnesses and evidence. And I'm very pleased so far, and I'm sure my sisters are as well, with the fantastic cooperation we have been receiving from Council this morning. We will test that cooperation, I'm sure, on this next item. So, there are issues of fact in dispute, evidently, in this case. And when this occurs, obviously, those disputes are resolved by evidence, written and oral. So, first of all, the question for the parties is whether you have witnesses that you wish to offer to provide evidence, and also, secondly, whether you have any documentary evidence that you wish to provide in this matter. Could we hear first from the claimant?
Your Honor, we do have witnesses, we do have documentary evidence, and it may be an appropriate juncture for me to raise a question as to documentation which is held by CARICOM and is said to be restricted access, that Your Honors would recall is specifically pleaded in the defense. I raise that now because it is an issue of disclosure of those documents to the parties in these proceedings, because those documents in particular would be of tremendous assistance to the court in determining the interpretation question touching the Charter of Civil Society. We have, I don't know whether you wish me to go into detail as to proposed evidence for the claimant, Your Honor.
Please, yes.
Proposed to call two witnesses, Dr. Ramsamooj himself and a Surinamese witness called Mr. Agnew. We will produce documentary evidence that mirrors the evidence attached to the originating application. But I would, of course, wish to reserve my position on that because there will be more extensive documentation as we deal with all of the matters which are joined in the pleadings.
Thank you very much.
Yes,
sorry.
Your Honor.
Please go ahead, yes.
There's one other matter, which is the question of expert evidence. I don't know whether you are dealing with that now or you propose to deal with that separately.
Separately, please.
Very grateful to you.
Okay. May I ask what is the nature of the difficulty you have had in accessing the documents from CARICOM?
Your Honor, we wrote to CARICOM and the response that we got was that the request that we had made was too broad. We proposed to write again. However, we understand that you have the power under Rule 24 to make an order that CARICOM produce those documents for the benefit of the court and the parties in these proceedings. The documents are the report of an intergovernmental task force that convened in Guyana in October 1996, and a second related document, which Your Honors might recall, are specifically pleaded by the defendant in its defense, beginning at paragraph 20. Those documents are the documents relied on by Professor Berry in his book for his proposition that the Charter of Civil Society is non-binding.
Yes, I would love to hear the opinion of my sisters on this if they choose to give one. But the point is for us to make an order of the kind that I think you are indicating, we would need to have a view from CARICOM, I imagine, as to why is it that there is resistance to supplying the documents you have asked for. And I think we would need to define a process whereby we interrogate that matter with CARICOM. I don't know whether Justice Rajnath Lee or Justice Onaniwu has a view on this.
I thank you, Chair. I don't have a view different to you. I think that the process by which we could hear from CARICOM as to the difficulty with disclosure would be important. CARICOM now being invited as an amicus. But it would be interesting as well, Chair, if we saw Mr. Phelps, and if you have put it in, Mr. Phelps, please forgive me in advance, but it would be interesting to see an application or the letter or something from Mr. Phelps so that we could begin a formal process of hearing from CARICOM. Thank you, Chair.
Chair, I agree. I think further information, we have heard from the claimant some indication of the nature of the documents that they would consider to be helpful, but I think some further information would assist the court to perform its role envisaged under Rule 22, 2 of the original jurisdiction rules that allows the court to require the community and other non-parties to the proceedings to supply documents and information. Thank you.
Yes. Mr. Phipps?
I don't wish to be misunderstood, and I did not intend to say to you that CARICOM had refused on the ground that those documents were not disclosable. The refusal to entertain my request was on the ground that the request was too broad, and I did not pursue that request. I was pursuing that request before you on the basis that your rules permit you to make such an order. And therefore, I wish to clarify two things. First, I have no basis for saying to you that CARICOM will refuse to disclose those documents. And second, I have not specifically asked CARICOM only for those two documents. However, my understanding of the court's sentiment is that I should communicate again for some clarification from CARICOM as to what its position is on those two specific documents. Whether you wish me to do so by correspondence or whether the court will oversee that process is a matter respectfully for you to direct me.
Well, subject to what my sisters say, I think this initial responsibility is with you, counsel, to seek to obtain the documents. If you have a difficulty which you cannot surmount, then we could consider the difficulty and decide how to proceed.
I'm very grateful to you, Your Honor.
Yes, Justice Rajnath Lee I made the point that we are ourselves not sure we are aware of the specific documents that you are requesting.
Are you hearing me? Hello?
I'm not sure who is speaking. Sorry.
The language interpreter, Dutch.
Yes. Okay. Yes, sir.
We had number. All right. Okay.
Judge, I think
okay
Ainde is having a separate conversation with respect to the interpreter. So he's muted now, so you can continue, Judge.
Okay.
Yes, thank you, Judge. Sorry.
So if we were to proceed in that way, I think that would be helpful. Justice Rajnath Lee, would you want still to see the nature of the documents that's being requested by
Not at all. No, not if Mr. Phelps undertakes that he will go back to CARICOM with his request.
Yes.
He may, of course, copy the court. That's his,
yes.
I believe he's free to do that. And if he does that, I'll perhaps copy the other side as well.
Yes.
But I have no objection to him proceeding in the way that he proposes. Thank you, Chair.
Is that acceptable, Mr. Phelps?
Yes, of course it is, Your Honors. We're grateful for your guidance and we will pursue it promptly.
Thank you very much. And you did say that you have, well, likely will have 2 witnesses. So we have made a note of this. Can you indicate whether, to the best of your knowledge, your witnesses are proficient in English and would give their evidence in English?
One is proficient in English, that is the claimant himself. The other will need your interpreter, Your Honor.
Aha.
He is Surinamese.
Yes, and the witness statement, I assume, would also need translation assistance.
That is correct, Your Honor.
And no doubt you're aware that there are rules governing that process of, translating the witness statement into the official language of the court, English?
Yes, Your Honor.
Right, and that process involves our registrar, as I'm sure you'll be aware. Okay. Anything further then on witnesses or evidence, documentary evidence from you, Mr. Phipps, or is that it?
No, thank you, Your Honor.
Thank you. Mr. Limapo, how about you? Do you have any witnesses or documentary evidence to offer?
Yes, Your Honor. I would probably have also 2 either prosecutors or police officers who were involved in the matter, and some parts of the penal code file as documents.
Okay, thank you, sir. And would these be in the official language of the court, the documentary evidence and the oral testimony, or not?
We would need to have this translated, Your Honor.
Okay, so the documentary evidence would be translated by a process I described earlier in relation to the claimant, which involves the intervention by our registrar. I think you may be familiar, Mr. Limapo, with that process, since you may have gone through it before.
Yes, Your Honor.
Wonderful. And in relation to the oral testimony, when we get there, the court, as I understand the rules, is responsible for having an interpreter, so that if the witness feels more comfortable giving evidence in Dutch, that then will be translated for the benefit of the court by the court-appointed interpreter. So that then would be the witnesses and the documentary evidence. Is that okay with both sides? Is that clear?
Yes, thank you, Your Honor.
Okay, wonderful. Mr. Limapo, are you comfortable with that?
Yes, Your Honor. Thank you.
Wonderful. All right. So can we then go to the next topic, which is the experts?
Chair, before you go on, could I just ask,
please
ask Mr. Limapo. Mr. Limapo, you have any idea how many witnesses you have?
I think so, 2.
I think this will be two witnesses.
Two. Thank
Yes,
you.
yes.
I missed that. Thanks a lot.
Yes. Okay. Experts. Now, of course, this is a fairly unique case because it involves looking at the domestic law in Suriname, and there is the particular doctrine reduced, I believe, to Article 40 of the Criminal Code, which I think many non-Surinamese lawyers would not be familiar with. And certainly, as far as I am aware, it is not a commonplace in international law. And therefore, we think that expert evidence would be necessary, at least on this specific issue. This came up at the last time we were together in October, and I believe the court offered parties the option of either seeking to agree, a common expert, or presenting their own experts. I'd invite you to remember that the court also has the power to itself appoint its own expert or to appoint an expert in lieu of all other experts. So could we inquire from you how far we have gotten on that matter of the expert witness?
Thank you, Your Honor. We did communicate with my learned friend in September of 2024, asking him for some information as to who he might have in mind as an expert, so that we could explore whether we could agree on an expert. We did not have a response, and we have proceeded to pursue our own expert. I am not in a position this morning to give you the name of that expert because we've been in discussions with two of them, and I require about 2 weeks to finalize the name of the expert that we propose to call, subject to your deciding that we ought to be calling two separate experts.
Yes. Thank you. Mr. Limapool?
Yes, thank you, Your Honor. That's correct. We received a letter from my learned friend on the other side, and I think I replied that we are looking into the option. We did take several actions internally. We had our minds on one expert, but he declined at a later stage, saying that he is ill and seriously ill, and he was not up to the task. So we have now two other options, just like the other side, two other options. We are waiting approval from their employer before we can disclose the name.
It would be a happy coincidence if the two that you're thinking of are also the two that the claimant is thinking of.
Might very well be.
Any chances of that happening?
Let me say this, if it's an expert who is let's say on the ground in Suriname, in practice on the ground, then it might very well be.
That would be very helpful indeed. Justice Anand, did you have any suggestions, directions to give in relation to the characteristics of the ideal expert?
Thank you, Chair. Chair, I think as we have discussed, it would be very helpful if the expert is someone who can provide guidance on the particular procedure as captured in the code, but also to provide guidance on how it has actually been used or implemented in practice, so that the court can have a fulsome understanding of how it is structured, but more importantly, how it actually has been applied. We have taken note that both sides seem to be exploring someone who has experience on the ground, if you wish, with respect to the contents and use of this procedure. And so we're very much looking forward to seeing the outcome of the exploration of this matter.
So just to underline the point that we are hopeful that the experts that the parties put forward are persons who are familiar with the practice, not just the text of it, but the practice of it as applied in Suriname. And of course, if we could have concurrence both sides as to one person, that would be really, really helpful. If there is no such concurrence, then the court would have to consider its option as to whether it would itself identify an expert instead of or in addition to those identified by the parties. Colleague counsel, if you could explore as fully as you can the possibility of identifying a common expert, that would be very helpful for us. I think that is likely to obviate the need for the court to think in other directions. And I think, if I may say so, Mr. Limapo, the ball in a sense might be in your court, since the claimant has already making an overture to you. So would you undertake then to respond to the claimant's letter as soon as it's convenient for you, with a view to seeing whether you could agree a common expert?
Yes, Your Honor, we will do. We hopefully we get the approval of the employer somewhere in the coming week, and then I will get back to my learned friend and see whether or not those names are acceptable from their side.
So can we agree a time frame then, within which we are likely to hear from you, I mean, collectively, as to whether you're able to reach agreement on this, and if not, the names of the persons that you propose to put forward? Would 3 weeks be a reasonable time to suggest?
Yes, Your Honor, I think from my side, yes.
Yes, thank you, Your Honor.
Okay. So within 3 weeks, we'll have the communication along the lines I just indicated. Sorry, my sister.
No. I'm happy that you completed that, Chair. I just wanted to, I believe I don't have to, but to look at 24.2 to say that we're always guided by that in the appointment of an expert, which would be the overriding duty of the expert to the court and not to the party who is instructing the expert. And I believe that 24.21 says it is the duty of an expert witness to help the court impartially on the matters relevant to the expert's expertise. Just to highlight that and the importance of that to our discussion, Chair. Thank you very much.
Thank you very much. And that hopefully will assist the central issue of whether we could have an agreed expert. That would be wonderful if we could. Thank you so much. All right. So the next point we had on our agenda was an agreed statement of the facts, issues, basic matters in dispute. I think we might be reaching a little bit beyond the ambition which has been manifest so far this morning. But may I ask the parties whether you think we could have an agreed statement of the facts and the issues in this case?
Your Honor, for the claimant, we believe that we could. The question, of course, is what the breadth of that document might be.
Yes.
Substantially.
Yes.
Substantially, the parties are not disagreed on the primary facts, if you will.
Yes. Yes. Mr. Limapo?
I do concur with my learned friend. We can try, and it depends on the breadth of the document.
Yes. Yes. Okay. And we anticipated that response might be forthcoming, and we are happy to identify and accept common ground. Of course, the breadth of the ground is what you're pointing to, but we'll take what we can get. I think that the issue of having identified the agreed facts, if we could then indicate those areas which are in dispute, that also would be helpful. So now I don't know if you can agree on the areas on which you don't agree, but to the extent you can, an indication of that would also be helpful. Thank you very much. time frame within which that can be done?
I suggest 4 weeks or 5 weeks, my lord.
So Lamapo, would you prefer 4 weeks or 5 weeks?
5 weeks, Your Honor.
Okay. 5 weeks. All right, great. Okay, fine. Thank you very much. So we come to the penultimate issue we have on our agenda, which is the written submissions. Pleadings are all in. We have agreed on the witnesses, agreed on the documentary evidence. Hopefully we'll get past the issue with CARICOM if there is one. And we get to the point then when we would invite written submissions from the parties. Again, we are trying to see whether we could line up a date for the hearing. Do you have any idea as to, that's a bit early now, but as to when we may be in a position to receive those written submissions, even in terms of a month? And also, again, I know it's very difficult, the length of the written submissions. And any ideas at this preliminary stage?
Your Honor, it is extremely difficult to estimate the length of the submission. What I can say is for the claimant's part, based on the work that we have done so far with regard to time, we would ask for quite a bit of time to put the submission together. A minimum of, I would suggest, 3 months, subject to the date that the court is earmarking for the trial. With regard to length, it is very, very difficult for me to estimate that with any precision, and I would ask, unless you direct me to do so, I would ask to be relieved of that obligation.
Sorry, you mentioned a number of months. Did you say 3 months?
I would have suggested respectfully that both my learned friend and I would need a minimum of about 3 months to put that submission together for you.
Okay.
I'm sorry, Chair. Is Mr. Phelps speaking about 3 months from today or 3 months from some other date?
I beg your pardon. No, 3 months, my lady, from today.
Oh, that is very helpful. Thank you, Mr. Phelps. Thank you, Chair.
And note that the rules do anticipate as a guideline 15 pages for the written submissions. Of course, one can make an application to adjust the length, but the basic rule, as I understand it in our rules, is that we anticipate submissions of about 15 pages. So please bear that in mind. The amicus, I'm sorry? The amicus, should such be appointed, would also be invited to make written submissions. I'm trying to recall, I don't know whether Justice Rajnath does, the process in the past whether we allowed the amicus to submit first so the parties saw what the amicus was saying, or the amicus submitted afterwards. I'm being advised that the norm is for the amicus to make submissions after the claimants. Justice Rajnath, do you have any institutional memory different from mine?
The only institutional memory I have, thank you, Chair, is that parties saw that not very helpful. They thought they should have seen the amicus before. But yes. I do believe, I'm not sure I saw that matter was being considered for review in our last revision of the rules, but perhaps it remained as it was. But when we heard that, and I think you recall that, Chair, it did sound like there was some sense to it.
Yes, I agree. Parties, do you have a view or preference?
My preference for the claimant would be to hear from the amicus first, respectfully, so
Yes.
that we would be in a position to grapple, if you will, with what has been said.
Liverpool?
I agree, Your Honor. Sorry, I agree.
Yes.
Please.
Yes. Yes.
The
Yes.
other side, Chair, of course, is that the amicus is also entitled to know what issues are being raised and how they're being argued by the parties and then put in their submissions. But I do believe, if I recall rightly, that we then gave the parties an opportunity to respond to the amicus.
Yes. Yes.
So
Yes.
in any case, they are heard and they can submit on the amicus. So I leave that, we can discuss that, Chair.
Yeah, I think it's interesting. Yeah, I do recall that. So would that be acceptable? That because, as my sister says, it's useful for the amicus to see not just the pleadings but the written arguments as well, and then to make submissions. But the parties will then be given an opportunity to respond to the amicus. Would that satisfy the parties?
It certainly satisfies us, yes. Thank you, Your Honor.
Yes.
Your Honor. Thank you.
And you're comfortable with that, Mr. Liverpool?
Yes, Your Honor.
Okay.
I'm comfortable.
Very well. I think we'll proceed in the way my sister just indicated, therefore. So, after the time, and we're happy for you to agree. You seem to have agreed on 3 months. The amicus would then submit, and then you'd have a further shortened time, I'm afraid, to respond to anything that you wish to respond to in the submissions by the amicus. So that is fine. The very last thing before we go back to something we said earlier is the format for the hearing. The question is whether we would wish to have the hearing in person, which would be at the seat of the court here in Port of Spain, where we have counsel and agents, we have the witnesses, or we have a virtual hearing, or we have a hybrid hearing. I should say that the preference of the court, we're not minded to impose that preference, but the preference of the court would be for an in-person hearing here at the seat of the court. But we are happy to hear arguments antagonistic to that view from the parties. The claimant?
The claimant would wish to align itself with the court's preference, Your Honor.
Thank you. Mr. Liverpool?
Yes, Your Honor, we have no objections. We do agree, fully agree.
Wonderful. Excellent. We're very pleased with the level of agreement that we have been exposed to this morning. We're very happy about that. Thank you very much. So the one matter we wanted to go back to is the issue of the witnesses, the evidence, and whether we could also develop some timelines in relation to that matter. I think both sides have indicated there are likely, and we don't hold you to this, but this is your position at the moment, have 2 witnesses each. And the question is, when can we get the names of the witnesses? When can we get the witness statements, bearing in mind the need for translation? Can we set some timelines for that so that we could have a comprehensive view as to how we move forward? Let's start with Mr. Phillips. I think you may have mentioned the names of the 2 witnesses you have in mind. Can you give us a rough timetable as to when you think you may have the witness statements available?
Might I suggest June or July, Your Honors?
June or July. Now, if you say the written submissions would be in within, say, 3 months, 3 months would put us where? Long before June or July, wouldn't it?
It would put us towards the beginning of April.
Yes. So why would you want to have the witness statements come in so late after the written submissions?
I was
Could we
only
do it earlier?
We can, Your Honors.
Yes.
Would it be in order to suggest May?
Is there any value or utility in having the witness statements in conjunction with the written submissions or not?
I'm going to suggest that we shift this written submission date from April to May.
Okay.
On the basis that marshalling the evidence to put together the witness statements is going to take a little bit more time
Yes.
than perhaps putting together the submissions would. I am, of course, subject to the courts.
No, I think that is fine, and I think Mr. Liverpool would associate himself with that. I'm pretty sure. It's customary for us to have the witness statements before the written submissions. So, if you are now saying, are you now saying about 4 months?
Yes, please, Your Honors.
So what if we said the witness statements within 3 months?
Thank you, Your Honors.
Now we want to make sure you're comfortable with that arrangement. If that is okay, and that sounds to me to be fairly reasonable, 3 months for the witness statements and then 4 months for the written submissions. Mr. Liverpool, how do you feel about that?
I have no problems with that, Your Honor. I think that's fine. That's
okay.
Fine.
Okay, great. So we have the written submissions. Then we have the submissions from CARICOM. Then we have opportunity to reply or to respond to the CARICOM submissions. And thereafter, we will have a pre-hearing review just prior to the actual hearing. So I think that if you were to be willing to stand by for just a few minutes, the bench would meet just to consider whether we could develop a rough timetable based on what we have discussed, and then come back to you to see whether that timetable meets with your approval. So could we stand down the matter for a few minutes, about 10 minutes or so, and then we'll be back with the summary of what we have agreed?
Yes, Your Honor.
Thank you.
Thank you.
Madam Deputy Registrar, could you transport us to the other place?
Yes, Judge, we will, our GC will assist.
Thank you.
Just hold a second. Thank you, Judge.
Madam Deputy Registrar, as soon as my sister returns, I think we'll be ready to resume.
She has, and court resumes. I'm seeing both counsels, so we can go ahead, Judge. Thank you.
Thank you very much. Well, again, thank you, counsel, for being so very cooperative during this morning's CMC. We have tried to capture the discussion and agreement that we had, and I'm going to ask our judicial counsel, Ms. Chelsea Dookie, to display on the screen the timetable that we have, we think, agreed. That, of course, is subject to any comments or modifications that you may wish to advance. So, first of all, we have agreed that CARICOM is to be added as amicus, and we will advise CARICOM and include that in the order, amongst other things here, which will be included in the order coming from the CMC. Second, the parties are to indicate whether there is concurrence in respect of the expert, and we discussed that. And I think we had agreed that the 13th of February would be an appropriate time. Parties are to file a joint statement of agreed facts and issues and indicate areas of disagreement. So that is to be done by the 27th of February. Parties are to file a list of witnesses indicating expert witnesses and list of documents by the 27th of February. Please bear in mind again the requirements peculiar to this situation where the language of one of the parties is not the official language of the court. Parties are to file witness statements, expert witness reports, and the documents they wish to disclose or which are required by the other side to be disclosed by the 24th of April, 2025. Claimant to file written submissions and list of authorities by the 29th of May. Remember the practice direction says 15 pages. We hope that that is sufficient. If it is unavoidable that it is not, then there has to be an application to adjust the number of pages. Defendant then to file written submissions and list of authorities, 19th of June. That's about 3 weeks later. The amicus will then file submissions, written authorities by the 3rd of July. Parties will be given a chance to respond to the written submissions of CARICOM by the 17th of July. It's about 2 weeks. You'll have to respond to CARICOM. We're proposing a pre-hearing review on the 24th of July, 2025. And then we are proposing the hearing date for the 16th and 17th of October, 2025. Now, in proposing the hearing date, we took into account the fact that there will be witnesses on the first day. We are not clear whether the witnesses will give their evidence and be cross-examined in time for us to have the oral submission from the parties by the end of that day. And therefore, in a sense, we have the 17th as a reserve day. We've also chosen those 2 days because our intelligence suggests that air travel to and from Suriname can be accommodated on at least one of our regional airlines to facilitate the hearing on these 2 dates. But on that last point, we are in the hands of Mr. Hans Limapo. He may have other intelligence, which would cause us then to have to adjust the proposed hearing date. So can we go then to go from the beginning and just ask counsel if there is any difficulty with what we are proposing here, because once we agree, we will embody this in an order of the court. Shall we start with the claimant? Any issues or comments?
Oh, thank you, Your Honors. All of the directions are convenient to the claimant.
Thank you, sir. Mr. Limapo for the defendant.
We have no objections, Your Honor. No objections.
Okay. What about that issue I raised about the travel to and from, or from and to Suriname? Are you comfortable with that? Could we go down to that date, please, Chelsea? Or do you wish to reserve on that? As I said, we thought that one of our regional airlines would be able to facilitate air travel to accommodate these 2 dates, but we are aware that there are other airlines which service the 2 territories. Are you happy with?
I think so, but I don't have the schedule of the Caribbean Airlines on top of my head, so for me it's not easy to say. But normally speaking, we would be able to easily access Trinidad.
Yes, well, since you mentioned them, I could say that that is the airline that we were looking at as well, and we thought that you could be. And I said you, I mean the one of our delegation from Suriname could be accommodated on Caribbean Airlines for these 2 days. But we are aware that doesn't Suriname, is it Airlines or Airways, fly to Trinidad as well?
Yes, Your Honor. Yes, Your Honor. So I
Okay.
mean, we will deal with it when we're in October. We'll make sure that we're at the court.
Okay,
We'll find a
good.
way.
But it's just that we want to make sure that we fix these dates in stone, so to speak. That has to be subject to any unexpected changes on the part of the airlines. But you know, we could give you a day or 2 just to make sure that you are comfortable. And once you are, or can we say until tomorrow? And once you are comfortable with these dates, then we will put them in the order. Would that be okay?
Yes, Your Honor. I am comfortable with these dates.
Oh, wonderful. Excellent. Well, thank you very much. Is there anything from either party? Anything else?
Not from us. Thank you, Your Honors.
Okay. Is there anything? Oh, sorry, Mr. Limapo, anything from you?
No, sir. Nothing
Okay.
from me either.
Anything from my sisters?
Not from me, Judge. Thank you.
Okay.
Not for me either, Chair.
Thank you very much. So thank you again, all. Again, apologies for the slightly late start. Madam Deputy Registrar, would you mind closing the proceedings, please?
Certainly, Judge. Thank you, Mr. Justice Anderson. Thank you, Madam Justice Rochnas-Lee. Thank you, Madam Justice Ononiwu. Thank you, Counsel, and thank you for your patience, and thank you to the hardworking, wonderful staff of the CCJ for all you did today. This court now stands adjourned. Good day to all. Thank you.
Thank you.
Thank you very much.